Under the GDPR, the term special categories of personal data refers to a set list of categories of information that is deemed particularly sensitive and therefore warrants specific protection and specific exceptions in order to be processed. By sensitive, what we actually mean is that should this type of data be breached, the impact to the data subject could be considerable. In this video, we'll look at what special categories of data are, we'll look at common misconceptions, common instances in which you may be processing those, and ways in which you can do so lawfully and in accordance to GDPR standards. Special categories of personal data are defined and regulated by Article 9 of the GDPR, which prohibits the processing of personal data that reveals one's racial or ethnic origin, political opinions, genetic data, biometric data with the purpose of uniquely identifying an individual, data concerning health, data concerning a person's sex life or sexual orientation. It may be worth noting that the list of special categories of personal data as provided in Article 9 of the GDPR is exhaustive, and it's not to be confused with the list of protected categories listed in the Charter of Fundamental Rights. So, Article 9 of the GDPR technically prohibits the processing of special categories of personal data, but it also provides 9.2, a somewhat extensive list of exceptions that would allow a data controller to process this category of personal data given the right circumstances. Those include the data subject's explicit consent, the necessity to carry out obligations or exercise rights of the controller or data subject in the field of employment, social security, social protection law, as authorized by union or member state law. The necessity to process the data in the vital interest of the data subject when they're physically or legally incapable of giving consent, or when processing takes place in the course of the legitimate activities of a foundation, association, or non-profit organization with a political, philosophical, religious, or trade union aim, but only for the data of current or former members and for purposes related to the work of the organization, and on the condition that the necessary safeguards apply and that data is not disclosed without the consent of the data subject. The processing of data manifestly made public by the data subject when the processing is necessary for the establishment, exercise, or defense of legal claims, where the processing is necessary for the purpose of preventive or occupational medicine, assessment of working capacity of the employee, medical diagnosis, provision of health or social care, and subject to safeguards. The processing is necessary for reasons of public interest in the area of public health. The processing is necessary for archiving purposes in the public interest, scientific or historical research or statistical purposes, and proportionate to the aim pursued. Now, as you can see, there are several exceptions, but realistically and in practice, only a couple would really be applicable to most companies processing special categories of personal data. Irrespective of the industry you may be working in, some internal processes are highly likely, if not certain, to process special categories of personal data. Don't worry though, that does not mean that you're automatically infringing on the GDPR. However, you should ensure that you are relying on the appropriate Article 9 exception, providing the right information to the data subjects, and ensuring appropriate standards of security, as this type of data is regarded as particularly sensitive. In any case, when reviewing your Article 9 exceptions, this is also the right opportunity to review your purposes, your legal basis, and your retention periods. As an employer, it's highly likely you will be at least doing one of the following: managing sick or maternity leave. Doing so will lead to the processing of personal data concerning health, meaning that one of the Article 9 GDPR exceptions must be relied on. In this instance, the necessity to assess the working capacity of the employee, Article 9.2g, would likely apply, while the latter is covered, depending on national legislation in regards to paternity and maternity leave, by the necessity to carry out obligations in the field of employment, Article 9.2b, and if that is not already done, the best practice would be identifying the specific legislation in your country to ensure that the processing is indeed appropriately justified by national law. Processing disability or religious status on employee tax forms. This is highly dependent on jurisdictions and relevant requirements in regards to employment tax. For example, here in Germany, where TechGDPR is located, employees are required to disclose their disability status and even registered religious affiliation in order for the appropriate tax to be levied and accounting codes to be displayed on the payslip. The relevant Article 9 exception here is to allow processing of data necessary to carry out obligations in the field of employment, Article 9.2b. Thus, in Germany, there's a legal obligation for employees to collect that information, but that would not necessarily apply in all EU countries where the processing of religious information would be a violation of privacy and data protection. This may not apply to everyone, but should your company wish to run specific diversity and inclusion programs to promote workplace equality, that might apply, depending on the target audience of the program. For example, programs aimed at the recruitment of more people of color or individuals of a specific ethnic background. The same would apply if the program focused on individuals from the LGBTQ+ community, whereby data concerning a person's sexual orientation would be involved. Notably, programs solely aimed at reducing gender gaps in the workplace will not be covered by Article 9 of the GDPR since, as mentioned earlier, gender is not covered by this article. In this instance, and where applicable, your organization may wish to rely on the necessity to carry out obligations in the field of employment, Article 9.2b, as certain EU jurisdictions, notably Germany, have anti-discrimination laws in place that require employers to take active, positive steps against discrimination. A diversity program can be considered to be one of those. Alternatively, one can choose to rely on the explicit consent Article 9.2.a of the data subject. However, this may be a little bit difficult in this context, as consent under the GDPR comes with strict requirements, including that of being freely given, which doesn't always look compatible in an employment relationship. On this specific point, the European Data Protection Board reiterated in its guidelines for consent that it is unlikely to be possible in an employment or recruitment context. Therefore, relying on the former exception may be the safest and most lawful option. Irrespective of the employment-related situations we've just looked at, you may also be processing special categories of personal data in the scope of the product or services you provide. In some cases, it will be straightforward for an organization to gauge whether it processes special categories of personal data. Organizations that work within the health sector and directly handle patient data or have access to it are highly likely to be processing data concerning health. However, understandably, some organizations may question whether, if they process special categories of personal data indirectly, they're still bound to abide by GDPR Article 9. As an example, in the preliminary judgment against the Chief Official Ethics Commissions in Lithuania, the European Court of Justice ruled that processing and publicly disclosing the name of one's spouse, which only indirectly provides information about one's sexual orientation, still counts as processing special categories of personal data. That is due to the specific wording of Article 9, stating that the data must belong to a special category of personal data rather than directly and explicitly stating it. The UK's Information Commission officer also aligns to this interpretation, providing that the criteria to apply is being able to infer information with a reasonable degree of certainty, or whether the inference of information may lead someone to treat the data subject differently. The Advocate General also came to a similar conclusion in its opinion on the case Meta versus Bundeskanzleramt, although in this case the AG concluded that if someone can come to a plausible conclusion based on the information given in regards to any special categories of personal data, then it should still fall under the scope of Article 9 of the GDPR. Regardless of the different wording used, one can consider that so far the interpretations of Article 9 are to include special categories of personal data that may also be inferred and not necessarily directly collected or processed, meaning that the relevant exceptions and special safeguards must apply to make the processing lawful. Special categories of data cannot be processed unless one of the Article 9 exceptions apply. They're somewhat specific and exhaustive, so it may not always be easy for an organization to choose an exception to legitimize the processing. However, for common activities that will inevitably involve the processing of special categories of personal data, you can rest assured that exceptions do apply so long as those processing activities are properly documented in your records of processing activities, and that the data subjects are appropriately made aware in your privacy notice. If you wish to find out more or have any specific question, or perhaps you'd like support in finding out whether you do process special categories of personal data and how to lawfully do so, then we provide ad hoc consulting on European data protection. Thank you for watching.